Makes sense now. I understand that I saw newspaper ads. They're just trying to hide the ball. It isn't.
Hello and welcome to another episode of Visa Vibes. My name is Emily Newman. I'm the managing partner of Reddy Newman Brown, a law firm in Houston, Texas that helps businesses with their work visas. And with me is my partner, Stephen Brown. Together we help companies, professionals, families navigate the complex immigration system in the United States that's always changing. And so what are we going to talk about today, Stephen?
Yeah, Emily, so first episode we did H-1Bs, all those myths and everything. And I think kind of on the same line is the PERM green card process. All these myths involved with PERM, right? This is the process for the beginning of most employment-based green cards, the EB-2, EB-3. And what's interesting, and I think what got lost in all this discussion, is you have, skilled and unskilled PERM. And people were conflating H-1B and PERM and all of it. So I figured it's a good topic today.
Yeah, it seems to be a hot topic on social media as well. There's people looking at newspaper advertisements that we for sure are for the PERM process, but making a lot of accusations about why are companies posting these things in the newspaper when nobody reads the newspaper. Well, there are valid reasons for it. So we'll get into that and try to break down some of these myths and misconceptions about the green card process. So first, what is labor certification? What is PERM? Labor certification has been around for a very long time. PERM is the new version of labor certification, and I say new in quotes because it's been around since 2005. It is the updated, modernized process in 2005 that was named the Program Electronic Review Management. All of that fancy words to say it went to an online system in 2005. Now, why can't USCIS make things online in 2025, 20 years later? I don't know. But DOL figured it out back in 2005. We initially filed these applications in the iCert system, which was the same system that we submitted LCAs under for H-1Bs. Now they've transitioned to the FLAG system, which is the Foreign Labor Application Gateway. So when we're talking about labor certification and PERM, what types of cases is this even for?
Yeah, so for the vast majority of employment-based green cards, right? So we have 5 categories, and in between those we have subcategories of our 5 employment-based. So let's talk about, EB1, not going to have a PERM. The 3 different ones under there. EB2 NIW, not going to have a PERM. Schedule A, EB3, not going to have a PERM, EB4, EB5. So what it is our EB2 and our EB3, skilled and unskilled, that are going to have a PERM labor certification designed to test the labor market to ensure that there's not a U.S. worker ready, willing, able to do the job.
All right, so there are multiple steps in this process before you can file an application. It usually kicks off with obtaining a prevailing wage determination. This is obtained from the Department of Labor before you can start the PERM process. And then the company has to, as you said, kind of try to find a U.S. worker. So they go through this recruitment phase that lasts for up to 6 months to figure out if they have any U.S. workers available for that particular position in the area of intended employment. If they can't find any qualified, willing, available, able U.S. workers, then they can proceed to actually file the PERM labor certification application. And once it's filed, it's taking over 1 year just to process. Now, back when PERM was started in 2005, they were supposed to process these applications in 45 days, and they actually did that. We received so many applications with fast processing times, and just over the last 20 years, that slowly kept increasing, and then over the last 2 years, 2 to 4 years, it just has gotten terrible, so it takes a year.
We know the technology's gotten worse, right? From 2004 for an electronic system. Yeah, it's, when they originally put forward the PERM regulation, they said, we think we can get this done in 21 days, and then the final regulation is 45 to 60, and we're now at 438 plus days to do something. By the way, takes 8 minutes per adjudicator. They're contractually obligated 11 to 13, but they were super proud that last fiscal quarter of 8 minutes per.
Yeah, and much of the adjudication is done through computer to make sure that everything was done when it was supposed to be done. There's a lot of, it's very intensive looking at dates and timelines and things like that. So that's all kind of pre-looked at. So I don't know why it takes so long, but that's where we are. So next we want to talk about what are the common myths and misconceptions about this particular process. So number one, when we're talking about a company who's choosing to sponsor a foreign worker instead of a U.S. worker, or not instead of, but along with their U.S. workforce, they're wanting to sponsor someone permanently to stay in that position. Myth number one, the employer gets to pay whatever salary they want and they get to undercut wages and cheap foreign labor and all that sort of thing. Is that actually true?
No, and I think number one, they have to pay the higher of the prevailing wage or the actual wage. And so what does that mean? When they start with that prevailing wage determination, they're going to submit to the Department of Labor, here's the job duties. Tell us how much we need to pay this person. And Department of Labor looks at the job duties. They're going to assign an occupational code, and then they're going to look at the area of the employment to determine that based off of all of the Bureau of Labor statistics and all this, here's the prevailing wage and the wage level, which we'll talk about, for this position. And so the Department of Labor sets it. And remember, one thing that I gets lost in this is that's kind of that minimum, right? And so that doesn't account for stock options or bonuses or anything like that.
So whatever that prevailing wage determination is, the employer has to agree to pay at least that. If they are already employing U.S. workers in similar roles and they offer them higher wages, that becomes the actual wage, and so they have to pay the same wage that they would pay. But they do list the prevailing wage on the labor certification form when they're actually filing that. And it looks at, as you mentioned, the job duties. It also looks at the education required by the position. It looks at how much experience is the position requiring for someone to be minimally qualified. So we're not looking for the best. We're looking for the minimally qualified workers here. So we're not trying to say that we're not going to hire a U.S. worker because this foreign worker is so great. Right. We're saying that this foreign worker is so great, we want to sponsor them. But our minimum requirements are X, Y, and Z, and that is what we are trying to hire someone for, not what the foreign worker has. That would be considered tailoring, and that is a big no-no through this process. But they also, besides the education and experience required, if there's any licenses required, any certifications, any special skills, does the job involve supervision of other workers? Does it require a foreign language? There's all kinds of different things that are considered special skills that actually will increase the wage requirement that the employer has to pay. So Department of Labor jumbles all that together and says this is the bare minimum, you have to pay at least that or whatever the actual wage is if it's higher.
And Emily, I think that goes into our second myth, is that these wage levels, they're just random, they're arbitrary. And there's 4 wage levels, right, that are set in Department of Labor guidance. It's a nice little matrix to come up with this determination, right?
Yeah, so every year the Department of Labor does conduct wage surveys to determine what is the range of wages that people are being paid for those positions in a particular area, typically the major cities or counties. And they divide that up into 4 different wage levels. So wage level 1 is generally associated with entry-level positions. Wage level 2 is more of your run-of-the-mill position. Wage level 3 is a senior level or supervisory role, something like that. And level 4 is the more complex, supervisory role, lead role.
Executive level.
Exactly. And so these are all, in every single occupation category is divided into these 4 wage levels, and that is what the Department of Labor provides to us. And we don't get to negotiate with them. We don't get to pick which wage level we want to pay. They tell us based on your education, experience that you're requiring for this position, and any of those special skills, supervisory, if the position involves travel or working at unanticipated locations, that will bump up a wage level, and that is the wage that the company has to pay.
Yeah, and I think there's ways to kind of project that out again, in this prevailing wage guidance from years and years ago. It's a matrix, and there's calculations on how to come up with it, so we can kind of make some projections. But it's irrelevant outside of being a projection, right? I mean, it's going to be Department of Labor to set that.
Yeah, and they do modify them every year. So every year, July 1st, they come up with the new wages. So it's always up to date based on what's going on in the job market. Now, once we get past obtaining the prevailing wage determination, usually the next step in the process is the employer actually has to try to recruit a U.S. worker. So they have to go through this recruitment phase. Now, can an employer actually skip that recruitment phase? Because they already know who they want to hire. They want to hire the foreign worker. So can't they just do that?
No, not at all. I mean, you have to go through this very rigorous process, and Department of Labor has lined it out. Here's what you have to do to open your recruitment and do a good faith recruitment, and here's the steps to do it. And they check that, right? They check to ensure it's being done, and it's requires posting with the state workforce. It requires newspaper ads, which you're going to talk about, because I think that's been the biggest fun topic online, is these newspaper ads. And then there's other methods that you have to use for your recruitment as well, based off of your normal recruitment efforts. And this has to be done within 180 days. You can't pass that 180-day timeline before filing your PERM.
All right. Speaking of when to exactly file the PERM, we've done our 180 days of looking for a U.S. worker. Can they just immediately file the application, or is there any kind of waiting period?
No. I mean, and again, this goes back to the idea of ensuring that there aren't U.S. workers that are able to do this job, is that they don't want to be like, okay, we ran our ads, so we're going to file tomorrow. Right. And then that's not going to work. So there's a 30-day cooling off period. So that way you can still gather resumes, gather in whatever, LinkedIn, whatever it might be, to ensure that's not still coming in.
All right. So what exactly are all of these different recruitment steps? Does a company get to just pick and choose what they want to do so that they can kind of hide the ball and not actually let a U.S. worker apply for the job?
No, so there's going to be 2 mandatory requirements, and then they can kind of pick from an enumerated list of the other 3. And so your 2 that are mandatory, they've got to run 2 Sunday newspaper ads. And Emily, maybe this made sense in 2004. To run classified ads in the newspaper of circulation for the area that they're going to work. Maybe that made sense. I get it. It doesn't make sense now. I understand that if I saw newspaper ads, they're just trying to hide the ball. It is a mandate to do these newspaper ads. So that's why they're there.
Yeah, and believe me, if an employer could skip the newspaper ad, because that's the most expensive part of this process, probably next to legal fees. I mean, some of these ads cost $4,000 or $5,000 to post in the ad. These advertisements for PERM are practically keeping our newspapers alive, I think.
If you've seen the Chicago Tribune building, it's beautiful, and I think it's substantiated through the PERM.
Yeah, so, and it has to be in a major newspaper. So here in Houston, we would have to place that, or the company would have to place that ad in the Houston Chronicle. And there are requirements for what goes in the ad even. So we can't skimp on what the requirements are for the position. The ad has to reasonably apprise a job applicant of what the job entails, where it's located, what those requirements are. And then if you're in a state that has the equal pay and transparency laws, the ad has to have even more in it in order to comply with that, which is completely separate from PERM. So there are a lot of things that the employer has to comply with in the PERM process, and those are set by DOL regulation. They don't get to pick and choose. They're not putting all these extra, making a huge long ad with all these requirements because they feel like it, but that's what they have to put in there.
No, and we have one of the preeminent oil and gas, companies here in Houston, and the building right next to us, and they can't just be hiring a petroleum engineer, call us, right? It's got to give all these specific details, and I get it. The newspaper ads. But that's one of the biggest myths. Everybody's looking at these ads and be like, they're just trying to put them in newspapers so they don't have to do good faith recruitment. It's a mandatory step. And then the other mandatory step is with the state workforce, right? So you have to place it with the state that the job is going to be in. Each state has a workforce job board, whatever you want to call it, a SWA, that hosts the job.
And on top of that, there is a notice requirement to this. So a company has to give notice in the place where the job is going to be to its other workers to let them know that, hey, we're getting ready to file this labor certification and sponsor a foreign worker. If you have any information, if you want to make a complaint, here's the address to contact the Department of Labor. And that has to be posted for 10 days before they can file the application, plus wait that 30-day cooling period. Now for the other parts of the process, so those are the mandatory steps, and then we basically have a list of 10 other ways that a company can recruit the U.S. worker. And these are meant to provide multiple mediums, different types of recruitment methods to basically get the job out there to a wider audience. So some of those can include job fairs. They can post on their company website. They can do an online job board like Indeed or Monster. They can go to on-campus recruitment with universities. They can do an employee referral program. So they have this list, an enumerated list of these are all of your other options. You have to do at least 3 of those. Radio, I've actually heard a couple of PERM ads on the radio before.
And so 5 things,
Yeah.
right, that have to be done to conduct this recruitment. It's not as easy as hiring a U.S. worker. And I think that's where this big question comes in. Are companies just using this PERM process to get rid of their U.S. workers and only hire this cheap foreign labor that, even though it's gone through the DOL process on the salary, that's what the recruitment's for?
Yeah, definitely not. I think companies that are going through this process, if they were able to find a qualified, willing, available, and able U.S. worker, they would hire those people. I mean, I talked to countless employer that says, we've had this position open for 2 years. We've been posting it on everything we can think of. So we hired this foreign worker, maybe on H-1B or L-1 or whatever it is. And now you're telling me I have to do these recruitment again to prove I couldn't find a U.S. worker when I haven't been able to find anybody in the last 2 years? Yeah, you do, unfortunately. So it's not something that employers are doing as a way to not hire U.S. workers. Every employer I talk to would rather hire a U.S. worker if they could. The visa process for sponsorship is much more expensive, has lots of compliance requirements, and then this green card process is very expensive, very cumbersome, not an easy process to go through. I think any company would rather hire a U.S. worker and avoid all of this if they could.
Yeah, and we know that there's been issues before. I mean, Facebook, right? A couple years ago, 2020, had a issue because Department of Labor said, hey, your Department of Justice alleged they weren't following good faith recruitment. So it is audited too. It's not just do whatever you want and it goes through. I mean, automatically.
Yeah, there's definitely an adjudication process. Yes, a lot of it's done by computer, but there are certain red flags that the Department of Labor is aware of, and they do audit these applications after they're filed. You have to have a whole recruitment file to show all of your compliance with these, that you've done the advertisements, you've done them at the right time period, because every ad has a specific time period. The newspaper, as you mentioned, has to be 2 Sunday ads. Can't do a Saturday ad, has to be 2 Sundays. And then you have to do the SWA, the State Workforce Job Order. That has to be 30 days, can't be 29. And then a lot of state workforce agencies open up the job to veterans only for the first couple of days. Those days don't count, so then you have to do 32 days. So there's a lot of math that goes into filing a PERM. So we talked a little bit about newspapers. These ads, one of the myths is that these companies are placing the ad in the newspaper to hide the job from real applicants so that they can't find it. Is that
No,
true?
and again, and you mentioned it, I think anybody that goes through this PERM process would be happy to get rid of newspaper ads. They are expensive and cumbersome. I mean, they're not easy to work with, those newspapers either, but it's a mandatory step. Department of Labor has said it is in the regulation. You can't just not do it. So,
yeah, and they have to provide information in this ad to let people know what the job is, let them know how to apply for it. And I think that's one of the areas you mentioned, kind of the Facebook case, and there's an Apple case. It came down to when the company is posting these ads in all these different medium that are required by the Department of Labor, it has to be in line with what the company's normal recruiting process is. It has to be this good faith effort to recruit U.S. workers. And so some companies would, in their advertisement, say, we want people who are applying for this job to mail in their application or mail in a resume versus submitting the application through the company's website, application tracking system, or emailing a resume to someone. It's mainly done for tracking purposes. Because of this compliance requirement. Companies have to keep track of every single person who is applying for this perm job. And so, DOL and DOJ kind of came in and said, we think this has a chilling effect on U.S. workers because U.S. workers are less likely to mail in their resume in 2020 in this day and age when everything's electronic. And so that case was settled. There was a fine paid. And then the other side of that is, I think with Apple, they were not posting the job on their company website. And now Apple, of course, has tons of job postings on their website, but the ones for perm were not somehow being posted on their job site. Now, the perm regulations don't require you to post on your company website. That's one of the optional options that companies have. But what they were saying is, well, again, you're making it harder for U.S. workers to find this job, and so it's not similar to what you do normally. Therefore, we think you are having a chilling effect on U.S. workers. You're discriminating against U.S. workers in posting these jobs. And so Apple settled as well. And the fact that this came to the Department of Labor and DOJ's attention and that fines were paid suggests that the process works. When something is not being done correctly, that's what that notice of filing is for, is to let U.S. workers know that we're getting ready to file this, and if you think we're doing something wrong, bring it to the Labor Department's attention. They will audit the case. They will open an investigation. They will make the company go through supervised recruitment, which is where the Department of Labor tells the company all the advertisements that have to be done, and then the Department of Labor receives the resumes so that they can track exactly who's applying for these jobs and figure out if there is a qualified worker out there for that job. With those two cases, I think it was both companies could clearly say that they were following the PERM regulations. They did not violate the regulations in any way, but were they having a chilling effect on U.S. workers who might apply for the job? Were they in good faith compared to what they do for their normal recruitment? That's where I think the problem could be. And this good faith recruitment isn't really specified in the regulations. It doesn't say you must do this in good faith, but it can be inferred because they have to, number one, attest when they're filing this PERM that the job opportunity has been and is clearly open to a U.S. worker. So if you're making it hard for the U.S. worker to even find the job, it's a little hard for you to say that the job has been and is open to a U.S. worker. And then the regulation also requires them to use their standard recruiting practices. So if they're normally posting these on their website, they should still be posting on their website, even though there are other options available under the PERM process. So ultimately, every employer who's going through this process has to review every application that comes in, determine whether they're a U.S. worker, figure out do they meet the minimum requirements for the position. And even if they don't meet the minimum requirements, they still have to consider those applicants to see if there's a way that they could meet those minimum requirements through reasonably training them. So it is not an easy task to get through all of that.
I mean, it's a headache for companies. I mean, think about, you've got to keep up with the timings of everything, your prevailing wage, when that's done, how long that takes, the recruitment, the timing on that, the proper filing. It's a giant mess that I think you're right. I think most employers would hire U.S. workers that, were qualified for the job.
Yeah, and then when they're posting these jobs, they cannot be overly restrictive. As I mentioned, they have to be the minimum requirements to do the job, not what our foreign worker has, not what would make someone best at this job. We're just looking at bare minimum. Could you reasonably do this job? If yes, the process has to stop. They can't be sponsored.
And we've seen that, right? We've seen companies, we've had, how many times have we talked to an employee that was like, they had to stop my PERM, for whatever, because they found folks.
Yeah. And if they do find a U.S. worker, if they're going to reject them, to proceed with the process. It can only be for lawful job-related reasons. So they can't just reject them because they're a U.S. worker. It has to be something tied to the job that, based on our interview with this person, based on their application, we don't think they could reasonably do this job even with some training, and therefore we need to hire the foreign worker.
And we're getting close on time here, but there was a myth, and I didn't put it on our rundown today, but everybody says perm is fraud. There's every perm, there's 116,000, 130,000, whatever that were filed last year. It's all fraud. So we depose. Well, we've got some things going against Department of Labor on this processing time and how long it is, and we asked the guy that runs the Office of Foreign Labor Certification that oversees this, like, what are your, how do you determine for fraud? Well, there's no fraud. We've never, we don't find fraud in this process. Why? Because it's so rigid, and it's a lot, but it's a checklist. Like, you got to do all these things to ensure you can even file the 9089.
Yeah, not many companies are going to go through all of that to file a fraudulent application. Like, what are they getting out of it? I don't know where.
It's a very expensive process that has a lot of checks to make sure that it isn't fraudulent before you can even get to the filing.
Yeah, and this is just the first step in the green card process. So after this gets approved, next we file the I-140 petition with the Immigration Service. They have their own background checks. They check into the applicant's actual foreign workers' education background. They make sure the company can pay the salary that the Department of Labor requires them to pay. So this is just a first step, and there's, again, not a lot of fraud being found in the I-140 petitions when we're filing based on this PERM. So I think there's just a lot of misinformation about what the purpose of PERM is, what these advertisements are representing, but hopefully we've been able to dispel some of that and give people a better understanding of why we have this process, what it does. Yes, it is outdated. Yes, it could be updated with the times. Hopefully we'll see that happen. But for now, for 20 years, this is what we have.
Yeah, so thank you. Second episode in, we appreciate you all listening, and feel free to reach out all of our social media platforms if you have a topic in mind. We always appreciate that.
Yeah, and be sure to subscribe on whatever podcast platform you use so that you'll be updated every time we upload a new episode, which should be on Tuesdays every week. So thanks for joining us.
Thank you.